There's going to be.
It feels not right to push a trial based on.
I'll be right back. Copy. Let's,
Hello.
Judge Dunn, mind if we have a copy?
Judge that.
I did, they're in his bag.
Well,
Yeah.
some people, Judge.
I don't know. And there's in Motrin's in the
Judge on super show, but he doesn't want
Motrin.
stuff that can stay.
Yeah.
So.
This one about 6:30.
See, we got the right back to.
I did.
That then we want.
Uh-huh.
Well, I think it's short, you guys saw what's that. But it's not. Is there a lack of
Yeah, so they can see.
It is popular. Well, it's a.
Yes.
Yes. We're on. Judge, can you hear us?
Yes, I can hear you. Can you hear me? Deputy Everett, can you hear me okay?
No,
Hold on,
sir.
it's very weak. Let me turn up the volume. Try again.
Is that better? Can you hear me okay?
Way better. All right, we're gonna call the roll. Jimmy Booker. Please say, here if I don't see. Bobby Evans. Bobby Evans. Jordan Patilio. Daniel Payne is verified in Tarrant County Jail. Ivan Restero. Hunter Tapper. I believe he showed up at Canton and is on his way over here.
Okay.
Chase Enoch. Jamie Nail. Carlos Padron. Braxton Henderson. Monica Roberts. Isaiah Smith. We will go over that in a minute. Wayne Dean. Audrey Andrews. Present. Charles Bennett.
He should be on the way.
Savannah Cooksey. Here. Jonathan Curtis.
Here.
David Dixon. Okay. Jeremy Hester.
Right.
Garrett Jocelyn. No Lehman. Julie McLennan. Did we verify she's in federal? She's still in federal custody. Christopher Nash. Deegan Tom. Kenesha Williams. Here. Tiffany Cooley. Here. Amber Chris.
She's on her way to the court.
Okay. Carlos Hernandez. Spencer Perry.
Here.
Joseph Rushing. Obed Menes. I'm sorry. How do you say the last name?
Mingus too.
Lanaria Miles. Here. And Debbie Spriggs. Here. Okay. Is there anybody here that we've not called your name? All right. And which attorney is ready? Yeah. So, Mr. Wood is ready on Miss Spriggs.
All right, step on up, Mr. Wood and Miss Spriggs. All right, give me just 1 second here. It looks like this is cause number CR 21372, State versus Debbie Renee Spriggs, and we're set for docket call. Mr. Wood, go ahead.
Judge, Mr. Woodward and I have been discussing this case. Ms. Spriggs is she's got some other things going on regarding another case, Your Honor. So we're asking that this be set off for a docket call again in December if possible. We think that it's set off in December. We think that the other issues might hopefully either be resolved or there be a more kind of telltale sign as far as what's going on in those particular situations. So we're asking that we set off till December, Your Honor.
Stays in agreement, Your Honor.
Okay. Court will reset Ms. Spriggs then for Mr. Wood. You have your calendar with you?
I do, Your Honor.
Looks like we have December 13th.
That'd be fine.
Will that work for you?
That'll work.
All right, court recess Ms. Spriggs then for December 13th at 9 a.m. And that's going to be over in Canton at the Justice of the Peace Court Precinct 2.
Thank you, Your Honor.
Thank you, Mr. Wood. We have any other attorneys that are ready?
I believe Miss Payne is.
All right, give me just 1 second, Ms. Payne, to get over to your client here. All right, this is cause number CR 22-200, State versus Wayne Dylan Dean. And I'm sure that we're set for pretrial. Ms. Payne, do you have any contested pretrial hearing or pretrial issues for hearing?
We don't, we're actually, it comes to an agreement with the state, we're asking for one more reset for a plea.
Okay. All right, court will then reset. Do you know, is there any specific time frame, Ms. Payne, on how long you need?
The month of November is strange, the week of November 14th is completely out because of my trial docket, but other than that.
You said November 14th?
Yes, specifically the 14th and the 16th are out for me.
Okay, what about November 8th?
November 8th?
Yes.
Yes, Your Honor, November 8th will work, it's fine.
All right, court recess the case for plea at 9 a.m. on Tuesday, November 8th at 9 a.m. and that will be at the JP2 Justice of the Peace Precinct 2 courtroom in Canton.
Thank you, Your Honor. May I be excused?
Yes, thank you, Ms. Payne.
Okay, Your Honor, Mr. White is ready.
Okay.
That would be Mr. Nolan White, I'm sorry.
Good morning, Mr. White. How are you, sir?
I'm okay, Your Honor.
Any certain order you want to go in, Mr. White?
No, sir.
Okay, we'll just go down the list then. Obed Mingastu, CR 22190. I show Mr. Mingastu set for docket call, first setting, I believe.
Yes, sir. We're gonna ask the court to move that to, another docket so we can set the plea.
For plea.
Yes, sir.
Any specific time request, Mr. White?
No, nothing specific, Your Honor.
Okay, I've got. Is that going to be for probation or for time?
It'll be for probation, Your Honor.
Probation. I've got November 8th and I've got November 10th.
Let's go with November 10th, Your Honor.
Okay. All right, Mr. Mingastu, court resets you for plea November 10th at 9 a.m. That's a Thursday. And that will be over in Canton at the Justice of the Peace Precinct 2 courtroom.
Your Honor, is my client free to?
Yes, I want Mr. Mingastu just check in with pretrial release before you leave. And if they don't need you any further, then you're excused. Okay. Lanaria Miles, CR 2238.
There's two judges. It's 39.
And CR 2239. Both set for docket call. Go ahead, Mr. White.
Your Honor, this is the first docket call I've actually appeared at. I talked with the state. I'm gonna ask for one more docket call. I don't think the state's has any objection to that. November, yeah. Your Honor, do you have anything, you got kind of a scheduling conflict on November the 10th? Do you have anything after that?
Looks like we have a couple set on November 22nd. That's the week of Thanksgiving, I believe.
November 22nd will be fine.
If we don't want that one, then I've also got December 1st.
Let's go ahead and do December 1st.
All right, Ms. Miles, court's going to set both your cases 9 a.m. December 1st, that's a Thursday, and you'll be in Canton at the JP2 courtroom. Is that all you have, Mr. White?
Your Honor, I have a case that was set for this afternoon on CR 2221. Mr. Christopher Jingo. We were set for plea. It's going to be for county jail time. And I talked with the state. We're going to ask the court if we can set it on the afternoon of October 25th to go ahead and enter that plea so he can go into custody that day. I don't think Ms. Heisel has any objection to it. I discussed it with her last week.
What's the reason he's not taking it today like he had planned?
Your Honor, he had a personal matter come up that hit his family. They had sold their house and they're trying to move out of it. And it's taken him a little longer than what he thought to get that done. I explained to him that, you know, if he does the full 30 days, which we assume we would do, that's going to put him through Thanksgiving. So he doesn't get to spend that with his family. He understood that. He said this was more important.
Any objection from the state?
Judge, Ms. Heidel's not in here, but I don't believe we have an objection.
All right, court will set Mr. Gingo on this afternoon's docket for plea on October 25th at 1:30.
Your Honor, I got a plea this afternoon, but that's all I have for this morning.
Yes, thank you, Mr. White.
Thank you.
Okay, Your Honor, Jeff White is ready.
All right, Mr. White. Good morning, sir.
Good morning.
Give me a second. Let me get back to the here. All right, I see you have two. Do you have two today? You have Mr. Hernandez, Mr. Perry, and Mr. Rushing. Which one do you want to go on first?
Well, go ahead and do Mr. Hernandez first.
All right, Mr. Hernandez, if you'll come on up, sir.
Your Honor, I believe we would need to go ahead and set this on a docket, but we will probably be doing a plea on that docket call.
Well, I show that we're set on docket call today. I'll show this is a fifth setting, which would probably be, and I don't have my LGS pulled up, but anyway, I show that it's set for docket call today.
Well, Your Honor, we're going to ask for one. We got a plea bargain late last week. And we are very likely to take one of two. But at this point, I need a chance to have an opportunity to speak with my client about it, which one we need to go. But I feel certain that it will be taken care of by a city.
And state, did y'all make revised offers, or is this the first time he's getting an offer?
Judge, my computer just locked up, so I don't know. I definitely spoke with Mr. White last week, and we did make an offer. I believe it was a revised offer. I think there was originally an offer, and we had to come down some. State would not be overly opposed to one more docket call, and hopefully we can resolve it at that time.
So you are opposed?
We are not opposed.
Oh, I thought you said you wouldn't be overly opposed.
Would not be overly opposed.
We're lawyers, right? We're wordsmiths. Okay, all right. Then, Mr. White, do you want to come back on November 8th or 10th?
Let's go with the 8th.
All right, court resets this case for November 8th at 9 a.m. Will that be, do you anticipate that plea to be for time or for probation, Mr. White?
It will either be for a time served or a pretrial intervention.
Okay, all right, we'll set for November 8th at 9 a.m.
All right, that sounds good to me, Judge. And my client has signed and received his reset notice. May he be excused?
Yes, as long as he's checked in with pretrial release and they don't need him, then he's good to go.
Next one, Your Honor, I got is Joseph Rushing.
Mr. Rushing,
Sir.
come on up. Go ahead, Mr. White.
Your Honor, we'd like to place this on the docket. I believe we can have a very good opportunity to get it resolved at the next November 8th docket.
Okay, are there any contested pretrial motions, Mr. White?
No, Your Honor, state has agreed to everything I've found.
Okay, all right, then the court will set this for docket call on November 8th at 9 a.m.
Okay, thank you, Your Honor. And my client can be excused. He's received his notice.
Yes, and Mr. Waddell,
Yes, sir.
I'm assuming that you're catching your clients as you need them, as they come in and out. Is that correct?
I try to, yes, sir.
Okay, I don't have a docket that's updated with notes from pretrial release. So if there's an issue, I'm not going to be aware of it. You'll have to either A, bring it to my attention or B, address it yourself there. Okay. So I'm just going to tell people to check in with you to make sure that they're free to go.
Yes, sir.
Thanks, sir.
And the next one, Your Honor, Session Terry, I've got the paperwork right now. We will be doing the interview complete once we go over.
Okay, thank you, Mr. White.
Okay, Your Honor, Mr. Castillo is ready on a plea.
Okay, come on up, Mr. Casilio.
Morning, Your Honor, George Castillo for the defense. My client, I'm here with my client, Jamie Nail. We have signed documents for the pretrial diversion program. We're ready to enter that and begin that program today.
Okay, great. And Ms. Heisel or Mr. Woodwhite, can you tell me what the terms of the pretrial are, just as far as the length and any other special conditions that I need to be aware of?
Yes, Your Honor, let me pull it up. I believe it's a Judge, it's a 2-year pretrial intervention with standard conditions. We've not added any special conditions. There is a weapon forfeiture of a Ruger 380 LCP semi-automatic pistol.
And is it PTI for the offense charge aggravated assault of a family or household member with a weapon?
It's ag assault of a ag assault with a deadly weapon. It is not, there is no serious bodily injury. That's the title, but it is a second degree.
Second degree?
Yes, Your Honor.
No family violence?
We're not asking for a family violence at this time. If we have to proceed, we might, but at this point, we're not on pretrial.
Okay. All right, Ms. Nail, just raise your right hand so I can place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can put your hand down. Ms. Nail, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Edward Castillo. Are you pleased with his representation of you?
Yes.
You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes.
Anything about this paperwork that you've read over and signed today that you do not understand?
No, sir.
You understand, Ms. Nail, that if you enter into this pretrial intervention contract, you're going to be giving up certain substantial rights. Do you understand that?
Yes, sir.
One of those rights that you would be giving up is your right to a jury trial in this case. You understand that you, as you stand accused today, you have the right to have a jury summoned for them to hear the evidence and determine whether or not the state has proven your guilt beyond all reasonable doubt. Do you understand that?
Yes, Your Honor.
And during that process, you would have the right to subpoena witnesses. You would have the right to confront the state's witnesses and cross-examine their evidence. Do you understand that?
Yes.
And you understand that if you waive your right today to a jury trial, that right may not be restored to you.
Yes.
That means if later let's say you enter into this contract and it doesn't go well and you end up going to a bench trial, you're still going to have a trial, but it wouldn't be before a jury. You don't get to later say, hey, you know what? I want that jury trial back now. You understand that, right?
Yes.
And Ms. Nail, has anybody threatened you, forced you, or pressured you to make you waive your right to a jury trial?
No.
All right, the court will find that Ms. Nail has been admonished as to her rights to a jury trial, and she's intentionally, knowingly, and voluntarily waived the same. Mr. Castillo, do you join in with your client in waiving her right to a jury trial?
I'm sorry, do I agree or understand? Is that what we got?
Do you join in with your client on waiving her right to a jury trial?
I do, Your Honor.
And does the state join in waiving its right to a jury trial?
Yes, Your Honor.
Okay. All right, the court will approve the waiver of jury trial in this matter. Ms. Nail, you also understand that you would be giving up other important rights, such as a limited waiver of your expunction rights, which means that if you successfully complete the program, you can still have your criminal records expunged in this case. However, you would not be able to expunge or remove the criminal records of the DA's office or that of the probation department, which would be supervising you. Do you understand that?
Yes, Your Honor.
Okay. And you also understand that you're agreeing that the state of Texas would be able to admit evidence in a subsequent trial if this pretrial intervention contract should not be successful. You're agreeing to serve evidence that may otherwise be inadmissible.
Yes.
Okay. And Mr. Castillo, do you believe your client to be competent today to enter into this agreement?
Yes, Your Honor.
Okay. All right, state, does Ms. Nail otherwise meet all of the other requirements of your pretrial intervention contract?
To the best of our knowledge, yes, she does. Your Honor.
Okay. All right, Ms. Nail, the court is going to approve the placement of you into the pretrial intervention contract for a period of 2 years. And so I'm going to ask you at this time, Ms. Nail, how do you plead? Well, let me go over this real quick. I forgot. The charge that you've been indicted with is aggravated assault, deadly weapon. Mr. Woodwike, is she indicted first degree or is she indicted second degree?
Judge, it's the heading, for whatever reason, says the more serious first degree. It is in the actual body of the indictment is very clearly a second degree felony.
All right, so Ms. Nail, you've been indicted with a second degree felony offense of aggravated assault with a deadly weapon. If convicted and sentenced on that kind of crime, the range of punishment could be anywhere between the minimum 2 years to the maximum 20 years in prison and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, Your Honor.
And understanding that, you still wish to go forward in this contract?
Yes.
All right, so Ms. Nail, at this time, how do you plead aggravated assault with a deadly weapon?
I agree with it.
I'm sorry, say that again.
I agree with it.
Well, no, do you plead guilty or not guilty to that charge?
Guilty to it.
Okay, court's going to take the defendant's plea of guilty under advisement at this time. Court's going to place her in the pretrial intervention program for a period of 2 years for aggravated assault with a deadly weapon. Court also finds that as a special condition, there is a weapon forfeiture of a .380 Ruger pistol. All right, Ms. Nail, if you'll go ahead and fill out the pretrial intervention paperwork, and you'll meet with the pretrial release officers or pretrial supervision officers, and they'll give you more information about your next step. Thank you, Mr. Castillo.
Your Honor,
Yes, ma'am.
Mr. Smith is talking with one last gentleman. Are you ready on Mr. Booker? I've printed out what you
Yes.
sent. Okay.
Yes, go ahead and bring Mr. Booker in. All right, this is cause number CR 22-239, State versus Jimmy Saul Booker. Mr. Booker, for the record, has been indicted with a second-degree felony offense of failure to comply with sex offender duty to register for life. That does carry a range of punishment of not less than 2 years or more than 20 years in prison, and that's absent any possible enhancements if there are any. Mr. Booker, go ahead and raise your right hand. I'm going to place you under oath today. Mr. Booker, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, you can lower your hand. Mr. Booker, are you still requesting to represent yourself in this matter?
Yes.
Okay, and so I have to ask you some questions today, okay? So, and I have to ask these questions so that I can make a judicial review of whether or not I can allow you to represent yourself, okay? So, Mr. Booker, how old are you?
I'm 63.
You're 63. And what kind of education do you have?
I have an associate degree in graphic design and technology. I have a total of 184 semester hours.
Okay. And Mr. Booker, have you do you have any specialized training in the law, or have you studied anything in your coursework along the lines of criminal procedure, evidence, penal laws?
Yes.
Can you tell me about that, please?
Basically, I've had pleadings filed in both criminal and civil proceedings. And back in '89, filed pleading, in to the 294 district court. And with one favor, Judge Stone was dismissed the charge. Somewhat similar to your case now. I've also, well, during my incarceration, filed on behalf of class actions for offenders where there was excessive force. And I've had about 27 years. I practiced great breed law while I was incarcerated for 27 years.
All right, thank you, Mr. Booker. And I'm not sure if you said this, but what is your work history? What's your work background? What do you do for a living?
I'm on disability at the present time. I've been mostly supplementing my income by lawn care, trimming trees. Yes.
Okay. And Mr. Booker, Mr. Booker, do you understand that if the court allows you to represent yourself, which you do have a right to do, but do you understand that if you move forward in representing yourself, that you will be given no special accommodation regarding your lack of any procedural knowledge or evidentiary knowledge regarding the rules of evidence or Texas law?
Yes, sir, I understand it under other versus state. Damage and disadvantage of representative I've been there.
And you believe that, understanding that you're at a disadvantage, you still want to go forward in representing yourself?
Yes, sir. Yeah, I got it.
And tell me again, I think you told me last time, but tell me again, why do you insist that you're better off representing yourself, knowing that you're at a disadvantage rather than having someone else represent you that is trained in law, procedure, and evidence?
Well, I feel like that if my attorney was in my shoes, that this case should have been dismissed based on the fact that I was arrested for failure to register when I had registered. That was the issue before the district attorney's office. And then once they discovered that I had registered, I don't see why he didn't file a motion to dismiss the charge. I understand that the results would also result in what? Basically illegal arrest and detention. But the district attorney's office went looking for a needle in a haystack in violation of Rule 201, 202, and 203 to find something to just make the case stick. And he hasn't represented me in that capacity.
Okay, and we've already dealt with your attorney. He's withdrawn and he's removed. So you believe that you are well equipped to argue all of the legal grounds and represent yourself. Is that what you're telling me?
I can also communicate with the district attorney's office, and we may be able to resolve this, without further action. But the right thing, I mean, in the eyes of justice, it should have been dismissed.
All right, thank you, Mr. Booker. Ms. Heisel, did you want to say something?
Yes, Your Honor, I just wanted to state for the record, I don't know how far Mr. Booker and Mr. Schmidt got into the arraignment process, but I just wanted the court to be aware and Mr. Booker to be aware that there are 2 priors alleged in the indictment that, if proven true, would make Mr. Booker 25 to life on this charge. So before he, decides to represent himself, I want to make sure he understands the full scope of what it is that the charges that have been levied against him are up against.
I understand that, and for the record, did you say how much you charge of failure to appear?
I'm sorry, I don't
So
understand.
failure to register. What does that carry? One
Yes,
year,
sir.
right?
The failure to register by itself is a 3rd-degree felony. However, the 2 previous enhancements that would make that charge 25 to life. So that is
But
what the state's proceeding.
that's only after the guilt phase, right? Enhancement phase. So-
Correct, yeah, if proven true, but that is what the state is seeking.
But the failure to register carries a 1 year state punishment.
I can't advise you, Mr. Booker.
All right.
And Ms. Heisel, will you double check your indictment? My docket showing this is a an F2 versus an F3. Doesn't mean it's right. It just means that's what it's showing.
Your Honor, it does show, on the face of the indictment to be a second degree. I thought that it was a third degree, so that may be, that may just be a misnomer at the top, of the indictment. I don't have my code book ahead of me. I know that that's, the original charge, but I thought that I had changed it, to a third degree, Your Honor. That's my understanding.
Well, and I guess either way, if there are two additional enhancement paragraphs, it would end up to be 25 to life either way, correct?
That's correct, Your Honor.
Okay. All right. So, Mr. Booker, I understand that you and Mr. Schmidt, y'all didn't see eye to eye, but you don't believe that there's another attorney that you could hire that could assist you, that you believe you would see eye to eye with?
No, sir, I fully understand the concept of court appointed attorneys. I know where to get the food, how they pay the bills, and all. He's not adequate to represent me. How he pays starting those bills. And it's more or less that he's a wolf in sheep clothing. If he couldn't get this case dismissed based on the fact that I had registered, then I don't see why I'm still even standing before this court today. George, the only issue before the district attorney's office was whether I had registered or not. He went looking for that other needle in the haystack. But the point is this: either I registered or didn't register. And I was adjusted. If I registered, then it should have been dismissed.
Understand. All right, Mr. Booker, I believe that Ms. Abraham has a document. I want you to, have you read over that document yet?
Yes, sir. I'm about to finish it up now.
Okay. I want you to read that out loud. I want you to read that out loud slowly to the court reporter so she can take it down and so that I know that you understand it.
Right. Beretta one is waiver of court appointed counsel. Court findings in order, allowing defendant to proceed pro se. The defendant has expressed the desire to represent himself, herself. If a defendant properly asserts his or her right to self-representation, then the record must show that she knowingly and intelligently waived his or her right to counsel after being made aware of the dangers and disadvantages of self-representation. The court informed the defendant that while he or she may waive the right to counsel and insist on self-representation, he may not obstruct the order procedure of the courts or interfere with the fair administration of justice. According to Will versus State. The court inquired as to the accused age, background, and educational experience, including legal experience. The court informed the accused of one, the general nature of the offense charge and the possible penalty. Two, that there are technical rules of evidence and procedures with which he will be obligated to comply, and that he or she will not be given special consideration because his or her lack of legal training or legal experience. He or she has no right to stand by counsel on the Scarborough State. The court has advised me of my right to representation by counsel in the charges pending against me. The court further advised me that if I were unable to afford counsel, an attorney would be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel. I wish to waive that right. I further request the court to allow me to proceed with my cause without an attorney being appointed for me. Wishing to proceed pro se, I waive my right to counsel.
All right, Mr. Booker, stop right there. So do you agree with all of that?
Yes, sir.
And you agree that we've talked about all those things?
Yes, sir.
Okay, so if you'll go ahead and sign right there where it says defendant and date.
It's signed.
Okay, and then Ms. Abraham will get that back. All right, Mr. Booker, do you have an email?
Yes, sir. That'll be Jimmy Booker.
James,
Jimmy.
Kenny,
Yes, ma'am.
Ms. Heisel, how would you propose Mr. Booker receive a copy of his discovery?
Your Honor, I would propose that he contact Mr. Crawford at our office to set up a time to come in and view that discovery at the district attorney's office.
Can you give him the contact information for Investigator Crawford and the address to your office?
I sure can, Your Honor.
All right, so Mr. Booker, this is what we're gonna do. I'm gonna reset your case for pretrial, okay? And what that means is I'm gonna give you time to go and review your discovery. And then we're gonna come back on, would you rather appear on November 8th or 10th?
It really doesn't matter, just send it to the team.
Okay. We're gonna,
Send it to file my own discovery motion. We'll look through that.
okay, court's gonna reset Mr. Booker for pretrial on November 10th at 9 a.m. And you'll need to meet with the DA's office and get a copy of your discovery and review that. And of course, you'll need to have your pretrial motions, any contested pretrial motions, motions to quash, motions to dismiss, any of those things filed in accordance with the code at least 7 days prior to that November 10th date. Failure to meet that procedural deadline may result in the court denying your motion.
That's fine with me, Your Honor.
Your Honor, I believe the defendant didn't report to Ms. Clark. He said he was scheduled to see her on the 28th. And did not report.
You said he did or did not report?
Did not report, Your Honor.
Mr. Booker?
She was out of office.
Ms. Clark was out of the office?
That in and of itself was not an excuse. There are other officers that we cover for one another in the office. Typically, Mr. Gann would have seen him if she was unavailable. So we have a law. Yes, sir. Did she give you a different woman to come see her? But you didn't see her in the month of September. In the month of February.
Do we have any other violations or any other concerns with Mr. Booker? Mr. Waddell?
No, sir.
All right, Mr. Booker, I want you to report to Ms. Clark today. And I want you to be UA today. So Mr. Waddell, if you'll go ahead and do the UA today and then let me know how that goes. If that goes okay, then we'll send him over to Ms. Clark.
Yes, sir.
And what was your email? Jimmy Booker,
Yes, ma'am.
28.
Gmail that point.
Just sign right there. Let's just read that. Okay, Your Honor, at the top, we put Mr. Crawford's information on how to get a hold of him on the
Great.
top.
Thank you very much.
Okay, so this is how you get a hold of Mr. Crawford. to investigate. And then you'll come back on November the 10th.
Yeah, man.
That's Carbondale with probation.
So Mr. Booker, you're going to step outside and you're going to meet Mr. Waddell and you're going to take a drug test today.
Right, we do that.
Wow.
You know, one where you get this, you cash out.
Mr. Booker, before you leave, Ms. Heisel, do we show that Mr. Booker's been arraigned? Most likely so if we're set for pretrial, but
Judge, I believe he was, but I don't have written record of that.
You know, is this not the one? I think he had you read this on the record, didn't
That's
Mr.
correct. Yes, Your Honor, you're
he? Yeah,
correct.
that's right. That's right. Okay. All right, Mr. Booker, step outside and meet with Mr. Booker.
Before we close, John, that would constitute double jeopardy. If I've already been arraigned and made bail on the same thing. And she decides to go look for a legal in the haystack. And then I come back up for arraignment to be make bail again. The double jeopardy clause.
Go see Mr. Waddell, Mr. Booker.
I just wanted to make that on the record.
You've made the record. Do we have any other attorneys that are ready?
Yes, sir. Mr. Smith is. I'm sorry, Mr. Grant.
Good morning, Mr. Schmidt.
More.
Who you want to go on first, sir?
Judge, I'm ready on all my clients as well as a arraignment on Mr. Todd.
All right, we'll just go down the list. And Audrey Andrews, CR 22-237 pretrial. Go ahead, Mr. Schmidt.
Judge, at this point, we don't have any contested pretrial. We'd ask to be set for docket call.
All right, court will find there are no contested pretrial motions. Court will set this matter for docket call November 8th. Any problems with that, Mr. Schmidt?
No, sir.
That's a Tuesday.
Yes, sir.
Thank you, Your Honor.
You're welcome. Charles Bennett, CR 22-125.
Judge, he's out in the hallway. Mr. Bennett's looks really crappy. He's complaining of sickness. I left him out there, but I can bring him in if you'd like.
That's okay. That's okay. If you're telling me that he's there, that's fine. It really depends on what we're going to announce on docket call, whether or not I need to know if he's rejecting the offer and those things, but go ahead.
Sure, Judge, and I know we're running up on a few docket calls. We're gonna ask for one more additional docket call and see if we can't resolve it.
Any objection from the state?
Judge, it's only the third setting on the newer case. We would be unopposed to another docket call on that, carrying the older case along with it.
All right, court will reset Mr. Bennett then for November 8th at 9 a.m. for docket call. And that's going to be over in JP2, Mr. Schmidt.
Thank you.
You're welcome. Savannah Cooksey, CR 2293. And Mr. Schmidt, if you want to step outside and let Mr. Bennett get out of there, I'm fine with that.
Yeah, let me do that real quick.
Yeah, go ahead. All right, this is CR 2293, State versus Savannah Cooksey for docket call.
That's correct, Judge. We're gonna ask for an additional docket call on Savannah Cooksey. We were in the process of securing some records on state benefits for the DA's office. And Ms. Cooksey had her bond revoked by this court, so we got delayed. So we're asking for an additional docket call order on it.
Take that approach, Your Honor.
All right, court will reset Ms. Cooksey for docket call on November 8th at 9 a.m. Do we think that could be a final docket call, Mr. Schmidt?
I hope so.
Jonathan Curtis, CR 21-210, 2021-192. Both set for Dr. Call.
Judge, same announcement, ask for additional doc call, see if we can't resolve this with stay.
No objection to the state, Your Honor.
Tell me where we're at on this, and maybe my docket's wrong. I'm showing that we've had 20 settings in one and 16 in the other. Is that right, or is that wrong?
Judge, it's probably wrong. I'm looking at this as a separate doc call, and it seemed to me like we were should be set for a pretrial today.
Yeah, and Ms. Chester was on this case before, I believe.
Oh,
He's
okay.
been on jury selection for months, Judge.
Oh,
I recall now, Judge, this is, I took over for Ms. Chester and asked to be set on a doc call, but ultimately I'd ask for an additional one. I think we're gonna make some progress on this case.
Okay, good. Well, and that makes sense as to why there's so many settings, because he was coming monthly for jury selection. So, all right, court will set this for Dr. Call on November 8th at 9 a.m. in both cases. All right, let's see. David Dixon, CR 22-269.
Judge, Mr. Dixon was here this morning. He met with Carl Waddell. I filed a waiver of arraignment. In addition, he set for 11/8 for pretrial. And I believe I discussed that with Mr. Abraham. I believe after he met with Mr. Waddell, we released him.
Okay, very well. All right, so record will reflect that Mr. Dixon is set for pretrial on November 8th. Jeremy Hester, CR 21-291. Mr. Hester set for Dr. Call.
That's correct, Judge. I'd ask for an additional doc call on Mr. Hester to allow us to continue to negotiate with the state. If the state's not opposed to that reset, would note for the court that Mr. Hester is due to have a baby, not him personally, but his wife, on that 11/8 docket. They'll be inducing her labor. So if the court would give us a different date than that 11/8 docket, that way he can be there for his childbirth.
All right, did you say before or after the 11/8?
After, please.
And is Mr. Hester doing well on pretrial release? Is there anyone from the probation department that can tell me that?
It's noted that he failed to report in September and he's never made a payment.
I made a payment last month when I left the courthouse, and I have my money order with me to make my payment this month.
Have you reported though, Mr. Hester?
Carl Waddell told me to see him when I came to court.
How much money do you have with you today for your payment?
I have a $60 money order for the court fees, and then a $25 money order for.
All right. Have you already met with Mr. Waddell today?
Yes, sir.
Okay. All right, court will set Mr. Hester for Mr. Schmidt, what do you think? November 20, how about December 13th?
That'd be fine, Judge. Thank you.
All right, December 13th at 9 a.m. That'd be at JP2, Mr. Schmidt. Garrett Joslin, CR 22-149. Mr. Joslin set for docket call.
Correct, Judge. Ask for additional docket call.
Excuse me. Any objection from the state?
No, Your Honor.
All right, court's gonna set for a final docket call on November 8th at 9 a.m. So state, if you're gonna make any better offers, I want to please make them well in advance of November 8th so they can make an announcement.
Thank you.
Noe Limon, CR 22-108. Set for docket call. Go ahead, Mr. Schmidt.
I think we were met with Ms. Hyde this morning. I'm fairly certain that we're gonna resolve this when we come back. We're asking for a reset. I do know that Mr. Limon, he lives out of town, and we've been trying to get him into the office to go through the discovery just so that we can finalize the case, but I suspect that if we reset him for the 11-8 docket, we'll probably be prepared to enter a plea or resolve it.
All right, court will set Mr. Limon for November 8th at 9 a.m. Julie McClellan, CR 22-188-189.
Judge, it's my understanding that Mr. McClellan is in federal custody. I have no indication that he's going to be released from federal custody. So that's what we're here today for, the status on that.
And we're talking about Julie McClellan.
Yes, Your Honor.
Okay. Go ahead, Ms. Heisel.
And Your Honor, the state has communicated with Mr. Schmidt that once we receive indication that she's been formally charged at the federal level, we do intend to dismiss our charges and let them proceed with prosecution. To this point, we have not received that documentation, but I do show she is in federal custody, so I suspect that that will be coming soon.
Just confirm she is in federal custody.
All right, court will reset for status on November 8th. Christopher Nash, CR 21-388. Mr. Nash is set for docket call.
That's correct, Judge. We're gonna ask for an additional docket call, Mr. Nash.
Is this one that you've substituted in on, Mr. Schmidt?
Judge, if I could recall, I'd tell you I'd be lying. I don't remember. All right, he says yes.
Okay, he would know better than both of us at this point, so.
No, I slept yesterday a little bit.
All right, court will reset Mr. Nash for November 8th at 9 a.m. for docket call. Dugan Toms, CR 22-158.
If I could have just a second.
That's fine.
All right, Judge, we're ready to proceed on Mr. Collins. At this point, I believe the state, their offer is 15 TDC. And Mr. Collins would be rejecting that offer. And we would ask that it be set on the trial docket.
And Mr. Schmidt, I trust that you've informed Mr. Toms of the court's policy of no pleas after docket call.
He's aware of it, Judge.
Okay. All right, then the court will set Mr. Toms for jury selection beginning. Let me look here. Monday, October 31st. That'll be at 8:30. So Mr. Toms, you will not be going to trial that day, but you will need to check in and get a reset notice. And you'll keep on doing that until your case is reached for trial. Mr. Schmidt will not be required to be there until your case is reached for trial, okay?
Sure.
Make sure you continue to comply with your pretrial release. Kenesha Williams. Ms. Williams is set for pretrial CR 22-199.
Correct, Judge. We're going to ask for an additional pretrial setting. Ms. Williams is a resident of Benton County and has an odd work schedule. We've got her scheduled to come in next week to go through the discovery with me. So for that purpose, we'd ask for that 11/8 pretrial setting.
All right, court's going to reset Ms. Williams for a final pretrial on November 8th. Go ahead.
If I may, would it be possible to get that December 13th date for Ms. Williams instead of the 11/8?
All right, court will set Ms. Williams in for December 13th at 9 a.m. Ms. Williams, you're going to have to make time to get in there and talk with your lawyers about your case. Your failure to do so, I'm not going to hold up the case because you don't go in and look at the evidence. It's being made available to you. And so if you just forfeit that right, you can do so, but I'm not going to have any mercy on you because you're not getting in and doing what you're supposed to be doing. You understand?
Yes, sir.
And Mr. Schmidt, you said that did Ms. Taberham appoint you to another one today?
Michael Top, CR 22-00296.
You said Michael Tuff?
Yes, sir.
All right, Mr. Tuff, there you go. CR 22-296 set for arraignment. Have you had a chance to go over the indictment, Mr. Schmidt?
I have, Judge. Mr. Tuff's name is spelled correctly in the indictment. Here stands the charge against him. We waive formal reading. Enter plea of not guilty. Ask it be set for a pretrial.
All right, court will find that Mr. Tuff has requested court-appointed counsel. The court finds him to be indigent at this time. The court has appointed Honorable Richard Schmidt to represent Mr. Tuff. The court also finds that Mr. Tuff has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. Court will set this matter for pretrial. Do you have a requested date, Mr. Schmidt?
Judge, If I could get that December 13th date, I'm getting kind of stacked up on.
Sure. Yeah, December 13th at 9 a.m. Has Mr. Tuff signed his conditions of pretrial release?
Yes, sir.
Okay, and Mr. Tuff, you understand that on these conditions of pretrial release, you have to report, you have to drug test, you have to pay your supervision fees, you have to pay attorney reimbursement fees. You understand?
Yes, sir.
Okay, and if you violate or fail to comply with any of those, the court could revoke your bail and put you back in jail. Okay?
Yes, sir.
Okay, your Honor, Mr. Crane is ready on a plea on Mr. Padron.
Morning, Judge.
Good morning, sir.
How are you, sir?
Oh, I've been better, but I'm not too bad.
I understand. Got a heavy case.
Let's see where you're at here. There you are. All right, this is cause number CR 21-336, State versus Carlos David Padron. And Ms. Heisel, can you give me the terms of the plea?
Your Honor, this is going to be on a state jail felony possession of controlled substance PG 1 under 1 gram. State is recommending one plea of guilty that a finding of guilt be deferred, punishment be assessed in 2 years, community supervision, a fine of $1,500, $180 restitution to DPS, court cost of $290, and $35 reimbursement fees, Your Honor.
Any 1245s?
No, Your Honor, this is the only charge on Mr. Padron.
Okay, great. All right, Mr. Padron, if you'll raise your right hand, sir, I want to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Your name is Carlos David Padron, is that right? And Mr. Padron, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
All right, in this case, you're represented by your attorney, Mr. Crane. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Crane, do you believe Mr. Padron to be competent today?
Yes, I do, sir.
All right, and you've discussed the case with him and advised him what his rights are as they pertain to this case?
Yes, sir.
All right, Mr. Padron, you are charged by indictment with a state jail felony offense of possession of controlled substance in penalty group 1 less than 1 gram. That does carry a range of punishment if convicted and sentenced to not less than 6 months or more than 2 years confinement in a state jail division of TDC, plus a fine of an optional fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
And you've heard Ms. Heisel read the plea agreement. She's indicated that the agreement you want to enter into the state is that you would plead guilty to that offense in exchange for a chance to be on deferred community supervision for a period of 2 years. You'd have to pay your fines, your court costs, all those other fees. You understand that?
Yes, sir.
You understand that if the court goes along with this plea agreement today and later, if you violate any of the terms of your community supervision, the state could file a motion to adjudicate your guilt. That means to convict you, and they could bring you back before this court, and the court could conduct a hearing at that time. And it wouldn't be over whether or not you have possessed a controlled substance. In this case, it would be on, have you violated any of the terms of your community supervision? You understand that?
Yes, sir.
And if the court finds that you have violated any term, the court could adjudicate you, convict you, revoke your community supervision, and sentence you to prison anywhere between that range of 6 months up to 2 years. And you understand that?
Yes, sir.
Okay. All right. So at this time, Mr. Padron, then I'm going to ask you, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
I'm guilty.
Okay. Court will accept the defendant's plea of guilt at this time. Mr. Crane, any objection to the state's evidence in this case?
No, sir.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
No, sir.
All right, Ms. Heisel, can you give me the facts?
Yes, Your Honor. On February 21st, 2021, Grensleen received a phone call for a noise disturbance, essentially that a vehicle is repeatedly revving its engine in the early morning hours. They go out to the location where the 911 caller indicates the vehicle is, and they find Mr. Padron essentially stuck in a ditch, revving his engine, trying to get unstuck from that ditch. They approach him, begin to speak to him. He does display signs of intoxication, so they ask for consent to search his vehicle. He does consent to the vehicle search. While they're searching the vehicle, they locate a baggie containing 0.08 grams of cocaine in between the driver's seat and the console, kind of down between the seat. And they place him under arrest at that time for possession of controlled substance.
Thank you, Ms. Heisel. Mr. Crane, any objection to that summary or anything you want to add?
No, sir.
All right, then based on the evidence, the court finds that there is sufficient evidence to convict Mr. Padron of this offense. The court will follow the plea agreement in this case. Court hereby defers a finding of guilt, places Mr. Padron on 2 years community supervision, orders him to pay a $1,500 fine, $180 restitution, $290 court cost, and $35 in reimbursement fees. Mr. Padron, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you step over with the deputy to be fingerprinted, and then you'll meet with the probation officers for more information.
Anything further, Your Honor?
Thank you, Mr. Crane.
Thank you, sir.
Quiet is ready.
Say that again.
Mr. Jeff Quiet is ready.
Okay. Bear with me, Mr. White, just a second here.
No problem, Judge.
This is Mr. Perry, correct?
That is correct.
All right, Mr. Perry, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. Your name is Chester Lee Perry, is that right? And Mr. Perry, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork, Mr. Perry, that you've read over and signed that you do not understand?
I understand it.
Okay. And Mr. White, do you believe Mr. Perry to be competent today?
I do, Your Honor.
And you've explained to him his rights as they pertain to this case?
I have, Your Honor. I believe he understands.
Okay. And Ms. Heisel, can you tell me what the terms of the plea are?
Yes, Your Honor, this plea is going to be to second-degree possession of controlled substance, PG1, between 4 and 200 grams. The state is going to recommend upon a plea of guilt that finding of guilt be deferred, punishment be assessed at 5 years community supervision, a fine of $1,500, $180 restitution to DPS, $290 court costs, $35 reimbursement fees, Your Honor.
All right. Thank you, Ms. Heisel. All right, Mr. Perry, you heard that plea agreement, did you not?
Yes, sir.
And that's what you're asking the court to approve today?
Yes, sir.
And you may have heard me tell the young man before you about the advantages and disadvantages of a deferred adjudication plea. Do you know what those are?
Yes, sir.
You understand that a deferred adjudication can be a great tool if you successfully complete it to have the case dismissed.
Yes, sir.
However, if it's not successful, then you could be facing the punishment range of not less than 2 years or more than 20 years in prison. And the court gets to set that sentence anywhere between that minimum and that maximum if you violate your community supervision conditions. You understand that?
Sir.
All right, understanding all those things, you still wish to go forward?
Yes, sir.
Okay. All right, Mr. Perry, then how do you plead to the second-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams?
Guilty.
Are you pleading guilty to that offense because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you, Mr. Perry, to plead guilty?
I'm sorry.
All right, court will accept the defendant's plea of guilt. Mr. White, any objection to state's evidence?
Objection, Your Honor.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Go ahead, Ms. Heisel.
Thank you, Your Honor. On November the 12th of 2021, Mr. Perry was riding a bike at 9:45 p.m. At Highway 80 here in Edgewood. The officer observed him, no reflective tape or anything like that, crossing the lanes of Highway 80 multiple times. Mr. Perry was using a flashlight on his cell phone as the only means of light for safety. So the officer made contact with him as concerns for Mr. Perry's safety. While speaking with him, Mr. Perry appeared very nervous, refused to take his hands out or wouldn't take his hands out of his hoodie pocket. At that point, the officer, becoming concerned for his safety based on Mr. Perry's behavior, did a pat down of Mr. Perry. When he patted the front pocket of the hoodie to basically see why Mr. Perry wouldn't take his hands out, he heard a crinkling noise that he suspected meant that there was contraband in that hoodie. He asked Mr. Perry what was in that pocket. And it was discovered that there was 6.99 grams of methamphetamine in that hoodie pocket.
Thank you, Ms. Heisel. Any objections, Mr. White?
No objections, Your Honor.
All right, then based on the evidence, the court will find that there is sufficient evidence to convict Mr. Perry of this offense. Court will follow the plea agreement in this case. The court hereby defers the finding of guilt, places Mr. Perry on 5 years community supervision, orders him to pay a $1,500 fine, $180 restitution, $290 court costs, and $35 in reimbursement fees. Mr. Perry, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step over with the deputy to be fingerprinted, and then after that, you'll meet with the probation officers for more information.
Thank you.
You're welcome, sir. Yes.
Okay, I think we're ready to start on ones that do not have attorneys, and unless y'all see Mr. Ashmore, he's supposed to be getting on Zoom for Mr. Enoch.
No, I don't see Mr. Ashmore. All right, here we go.
Okay, Mr. Patilio, Jordan Patilio, if you'll bring him up.
Jordan Patillo, CR 22193. You said he's here?
Yes, Your Honor.
All right, good morning, sir. Do you say your name Patillo or Patillo? Patilio. Okay, Patilio. All right, your name is Jordan Dion Owens Patilio.
I only go by Owens though. I don't use Patilio.
Say that again. You just use Owens? Say that again. I'm sorry, I didn't hear you.
Yes, sir. I only use Owens.
You don't use Owens? Okay, okay.
Jordan Owens.
Jordan Owens?
Patilio.
Okay. All right, so you have been charged by arraignment, I'm sorry, you've been charged by indictment and you're set for arraignment on unlawful possession of firearm by felon. That means that if convicted of this charge, you could face a possible sentence of not less than 2 years in prison or more than 10 years in prison and a fine of not more than $10,000. Do you intend to hire an attorney, represent yourself, or requesting court-appointed counsel?
Hire attorney.
You're gonna hire an attorney? And how long would it take you to hire an attorney that they can represent you on this? If I give you 30 days, is that enough? All right, so you're telling me that if I reset this to say November 10th, you can come back with your lawyer? Okay. All right, court will reset Mr. Patilio then for November 10th at 9 a.m. for arraignment and status to hire attorney. And Mr. Patilio, the next court setting will be over in Canton at the JP2 courtroom. It won't be in the same courtroom that you're at today.
All right.
Make sure you stay in contact with pretrial release officer and your bondsman.
All right.
And as soon as you hire your attorney, Mr. Patilio, put them in contact with the DA's office so they can get going on your case, all right?
Okay, Your Honor, if you would ask Ivan Rostero Garcia.
Ivan Rostro Garcia, CR 141. All right, Mr. Rostro, it appears that there's been a motion to adjudicate filed in your probation case. Do you intend to hire an attorney? Are you requesting court-appointed attorney? Are you going to represent yourself? How do you plan to resolve this matter?
We'll hire a lawyer.
Okay, if I give you 30 days, like I gave Mr. Patilio, do you believe you can have an attorney hired and representing you?
Yes, sir.
Okay, all right, court's going to reset Mr. Rostro then for hearing on his motion to adjudicate and status on hiring an attorney on November 10th at 9 a.m. So Mr. Rostro, I expect you to come back with your lawyer on November 10th.
Sir.
And as soon as you hire them, put them in contact with the DA's office. And Mr. Rostro, you're still on probation. Just because they filed a motion doesn't mean you don't have to report, drug test, and pay, okay?
Be required and do community service and make my payment, sir.
All right, thank you, sir.
And that was the 11:10, Your
Yes.
Honor?
Yes, ma'am.
Okay, he is supposed to be hiring Mr. White. Yeah.
Mr. Jeff Clark.
Okay, good.
We'll be back on November 10th. I believe that's at JP. So we'll be back in Canton.
Okay.
Oh, that's yours. Keep.
What about Mr. Tapper? Is he there?
Yes, sir.
Mr. Tapper, come on up. CR 2371. All right, Mr. Tapper, where's your lawyer?
I no longer have a job due to the prior arrest, so I'll have to apply for a court appointed.
Have you filled out your paperwork yet? You have or haven't?
I have.
Go ahead, Mr. Abraham.
Okay, he's completed his paperwork. He's said he's been unemployed for the last 3 weeks since the last incarceration. And he has no assets. He said he lost his car, correct?
So does he appear to meet under the guidelines?
Yes, Your Honor.
Okay.
So now we'll Will this be replacing also the other case where Mr. Files? We have him on page 3 also.
Does Mr. Tapper only has this one case, is that correct?
No, sir, he has 2. He has the one on page 2 and then the top of page 3.
Top of page, one on page 2 and the top of page 3.
He had the files on the new arraignment, on the new charge.
Did Mr. Files file a waiver?
Not that I know of, Your Honor, but he did tell me I'd have to rehire him for him to represent me.
Have you retained Mr. Files or Mr. Harrison to represent you on the sexual assault charge?
Yes, sir.
No? Ms. Tabraham, are you showing Mr. Files to be attorney of record on that?
The DA's office, when I checked with Ms. Abney, they had received something showing that he was on that case.
Judge, I believe that there's some confusion that maybe I can help with. Mr. Tapper is also on for a state jail NTR. Mr. Files represented him on both charges back in the beginning. Essentially by agreement with the DA's office, he pled on the state jail drug case with some additional conditions related to the sex offense, and the state agreed not to file the sex offense as long as he successfully completed his probation. He's here on a motion to revoke, which led us to filing the sex charge. But to my knowledge, Mr. Files has not represented him since the plea on the state jail Docket case.
Okay, so Ms. Tabraham, yes, he'll need to be appointed an attorney for both.
Okay.
And so let's set Mr. Tapper then for arraignment and also MTA. Do you know who you're going to appoint, Ms. Abraham?
Yes, sir, I'm ready.
No. Do you know who you're going to appoint?
Oh, I'm sorry. Mr. Manning.
Manning. Okay, I was looking at which date I need to do. All right, so let's set for arraignment and MTA on November 10th, Thursday. All right, so Mr. Tapper, the courts reviewed your request for court-appointed attorney, finds you to be indigent at this time. The court's appointing the Honorable Jonathan Manning to represent you. Ms. Tabraham is going to give you information on how to contact Mr. Manning. And then we'll send him notice that the hearing will be set on Thursday, November 10th. And you'll need to be in contact with him within the next couple of days and introduce yourself.
Yes, ma'am. Yes, sir. Thank you.
November the 10th, we're at JP2, right?
Correct.
We'll be in Kansas.
Thank you.
You're welcome. Ms. Tabraham,
You're right, yes, sir.
on Isaiah Smith, was he to be checking in via Zoom or is he there in person?
Your Honor, he appeared at the courthouse this morning, right after 8 o'clock when we were on our way over here. Ms. Barker, we reset him for
Okay.
November 8th because Mr. Massar had filed the motion for continuance.
Sure, okay. All right, I was just making sure on my end. Who else do we have in the courtroom who doesn't have a lawyer that we need to bring up?
Yeah, we have Mr. Estrada here, now with that.
I don't know if it's me or you. One of us is losing connection. I don't know if y'all can hear me, but I can't hear you guys.
You're right, about this, if you're looking at, working on this side.
Let me see. Are you there?
Judge, we can hear you on our end here.
Yeah, but I think they're muted. Patty, you're muted. There we go. Now I can hear you.
Mr. Estrada said, was it just because he walked up to the podium?
Mr. Estrada broke it as he walked up. Mr. Estrada, how are you this morning, sir?
Wonderful, Your Honor. Thank you.
All right, this is cause number CR 21-289, State versus Braxton Henderson. I show we're set for pretrial. Go ahead, Mr. Estrada.
Yes, Your Honor. All discovery, I believe, has been received from the state. And we're gracious that the state's been able to comply with our requests and our subpoenas. Offer was relayed to Mr. Henderson recently. That offer has since been rejected, Your Honor, Judge. There are going to be multiple witnesses in this trial, including various experts. I think the state and I have discussed requesting a special setting on this matter.
Okay. And so for record purposes, can you all tell me what the offer is that's been rejected so the court will be aware?
Yes, Your Honor. It's 12 years on a lesser charge of manslaughter.
Okay.
That's correct, Your Honor.
And Mr. Estrada, you explained to Mr. Henderson that if on the eve of trial, he decides that he wants to take that offer or a lesser offer, the court's not going to entertain any plea bargaining after today's date.
Yes, sir. He equated yes to the court.
Okay. And Ms. Heisel, is this the best offer the state's going to make?
Yes, Your Honor.
Okay. All right. So what I'm going to do, Mr. Estrada, is I'm just going to set him to begin jury selection on our regular trial docket in October. And then when I get back to the office, I'll work with Ms. Abraham on figuring out what dates we have available for special. Considering the nature of this charge, the court will set this. I just don't have access to that calendar today.
Yes, Your Honor, that's fine.
So what I'm going to do, Mr. Henderson, is I'm going to order you to report for jury selection on Monday, October 31st, there at the courthouse. Ms. Abraham, is that where you're going to be?
Yes, Your Honor.
Okay, so you'll report there, Mr. Henderson. You will not go to trial that day. You'll just check in and you'll receive a reset. You can arrive between 8 and 8:30. And Mr. Estrada will not be required to be there because your case will not be going to trial that day. Do you understand?
Yes, sir, Your Honor.
Okay. All right, then we'll see you on October 31st. And then Mr. Estrada, once I figure out when that special setting date is, I will email you and the state and see if there's going to be any scheduling issues for that time for the both of you. And if not, then we'll get it set.
Yes, Your Honor, that's fine. Judge may be excused.
Yes, thank you, Mr. Estrada.
All right. Did we say Mr. Ashmore yet?
No.
No.
What about Mr. Green and Ms. Roberts?
Your Honor, I believe Mr. Green filed a motion for continuance late Friday, but I'm gonna have to verify that.
Is Ms. Roberts there though?
No,
That's not good.
no. Okay, Your Honor, we have in the courtroom, Ms. Thompson's, Ms. Cooley and Ms. Cr. If you want to bring one of those up.
Oh, is Ms. Thompson's there?
No, remember, she filed a motion for continuance.
Have they all checked in with pretrial release? Will you just go,
Yes,
will you ask Carl to make sure there's no issues?
yes, sir.
We need to.
Your Honor,
Yes, sir.
both defendants have not paid any on their fees. They're both $120 delinquent. They have been reporting. Miss Cooey has reported consistently in the past in county court of law prior to the case being moved upstairs.
Okay. Ms. Cooey, Chris, if you'll approach.
Your Honor, can I say something?
Yes, go ahead.
They have both voiced to me, concerns that they have not Miss Chris says she has not spoken, with Miss Thompson since she was arraigned. Miss,
I spoke for about in the last 3 years, she had reset me and reset me and reset me.
they said that they're just getting reset, and so, Miss Chris said she's only talked to her 5 times in 3 years, so I believe that they both are concerned that they've been reset last time because she wasn't here, and then today, so I just wanted to bring that to your attention.
All right, Ms. Chris, Ms. Cooey, y'all both come up. CR 22-208, State versus Tiffany Cooey. CR 22-209-210, State versus Amber Nicole Chris. All right, ladies, Ms. Thompson has filed a motion for continuance. Court granted that. I'm resetting each one of you for November 8th. So what I want, if y'all have complaints against Ms. Thompson, I want you to speak with Ms. Taperhand. There's paperwork that you can fill out. And if you want another court-appointed attorney, you need to make that request in writing, okay? And the court will consider that, but I need you to put that in writing for me so I can have it in the record, okay?
Yes, sir.
All right, so y'all step over and sign your reset notices for November 8th. Tell me, have y'all spoken with Ms. Thompson by phone?
She's so hard to get a hold of. I've been reset. I've seen her like 5 times coming to court in the past 3 years.
Okay. All right, y'all step over, sign your reset notices for November 8th, and then save your hand if you can give them the information they need, if they're wanting to have different court-appointed counsel.
That's my email. Just send me the email. Yeah, that's. Somebody else concerned.
All right, I do have Mr. Atmore, so Mr. Enox will come on up. Let me see if I can get him to start his video. All right, Mr. Ashmore, can you see and hear me okay? All right, Mr. Ashmore, can you see and hear me okay? Yeah, we're not picking you up. Audio. We've got you on video. Make sure you're not connected to your Bluetooth in your car. Okay, I think we can hear you now. Mr. Ashmore. I think we can hear you.
Okay, I think I can hear you too now, Your Honor. I apologize for being tardy. I was at the jail. I did not realize I had anything. I thought I was not set until 11 a.m. in your docket. I'm ready on Mr. Enox. And again, I'll ask the court's forgiveness for my tardiness.
This is cause number CR 21-324, State versus Chase Ray Enox, set for docket call. Go ahead. What's the announcement for Mr. Enox?
Judge, we have an offer from the state of Texas. We're prepared to accept. I'm in Canton. Mr. Enox is in Wills Point. And I understand that this has to do with the ongoing remediation efforts in the courthouse. I still have the request that I had from before, which was to permit Mr. Enox and I to resolve. There's a companion case that the court is aware of. It's before the court. We are trying to get a final order done and signed off by the parties. I thought we had agreed with the state to set this out further than October for the purpose of getting that resolved so we can finalize his plea paperwork. We're not there yet. And so if the court would entertain a final setting, I think we'll be done. It just couldn't get it done in the timeline that we had anticipated, Judge, and that's on me. I apologize.
When is the family law case going to be resolved, do you think?
We have a verbal agreement and we just need signatures on a final order. And I think that order will be done any day this week. And whether Miss Enoch signs off on that, ultimately I can't control her conduct.
Right, but tell me if you think that you have an agreement, or you're just.
I think we have an agreement. The agreement is just to put into the order a standard possession schedule and present it to her for signature. Now, her behavior has been anything but stable in the last several weeks, but she has at least verbalized that she will agree to that. Conduct outside the agreement has been anyway, it's just been odd with Miss Enox.
All right, so if I set this for a final docket call on November 8th or 10th, you believe that we can have a final resolution to this criminal case?
I do, Judge, and we might see if we can, if the court will squeeze us in, if we can get the order signed off on quicker than that.
You're talking about on the family law case?
And no, just if we get the family law final order before you and get it signed, I'd really like to ask the court to entertain the idea of just letting us come in on any docket. So we can be done in the month of October.
Okay. All right, court's going to reset Mr. Enox for. Let's look at either Tuesday, November 8th or Thursday, November 10th. Tell me which one looks better.
Judge, we'll ask for the 8th because we have some Veterans Day engagement starting on the afternoon of the 10th. So that'd be my respectful request.
All right, court will set Mr. Enox for a final docket call on Tuesday, November 8th at 9 a.m. And on that date, Mr. Ashmore will be over in the JP2 courtroom in Canton.
Yes, Judge.
Mr. Ashmore, while Mr. Enox is doing that, do you have anything this afternoon?
I do, Judge, and I think we have Mr. Reyes back in custody and set this afternoon.
Oh,
He
yeah.
was.
Here, I see that.
He was not present in court a bit ago, and so we'll be ready to make an announcement. I think he's.
You can go, Mr. Enox. Thank you, sir.
Thank you, Your Honor.
Thanks, Chase.
Yes, sir.
I'll call you in just a minute, sir.
Okay. All right, then I guess we'll see you this afternoon then.
Judge, I'll ask your forgiveness for the confusion this morning. I didn't think I was set till 11 in your court here. For whatever reason, that was on my calendar that way. So I will see you at 1:30, Judge.
Sounds good. Thank you, sir. Ms. Abraham, anyone else that's ready?
Your Honor, I believe we're down to Bobby Evans.
Okay. Mr. Evans does not have a lawyer, correct?
No, sir. He has completed. Come on, sir. He has completed his affidavit of indigency. He does not meet income-wise versus expense, but he does not have any assets. So the income is $2,400 a month, and the expenses are $1,015. So, but he does not have any assets, car, motorcycle.
How do you get around, Mr. Evans?
I haven't really been able to do a lot of driving because my license expired on me and I wasn't able to get it renewed because it was a speeding ticket I got in Emory. They turned it over to the DPS and then they put a hold on my license. And I've just fallen off into a big old hole, and to be honest, I let everything slip.
How do you go to work?
Well, I haven't been working every day, and when I do get to work, I have my mom take me, my boss sometimes picks me up. But that's why I put 800 to 2,400 a month, because I haven't been working 40 hours a week. If I work 40 hours a week, I would get around 2,400.
All right, Ms. Abraham, go ahead and appoint Mr. Evans an attorney.
Okay, it will be Mr. Smith.
All right, and we'll set him on December 13th. All right, Mr. Evans, the court's appointing Richard Schmidt as your attorney. I'm going to reset you to come back to court on Tuesday, December 13th. That's going to be over in Canton at the JP2 or Justice of the Peace Precinct 2 courtroom. And Ms. Abraham will give you information on how to reach Mr. Schmidt. Mr. Waddell, has he signed his conditions of pretrial release?
I'll let her answer.
No, sir, we do not have any typed. I will type those in for your signature today.
Okay, so Mr. Evans, the court is going to order you to comply with pretrial release conditions, and what that means is you're gonna have to report to a pretrial release supervision officer. That's Mr. Waddell there to your left in front of you. You're gonna be drug tested. You're gonna have to pay towards reimbursing the county for your court-appointed attorney, and you're gonna have to pay for a supervision fee, okay? So these are gonna be conditions. You posted bail in this case, and if you want to remain on bail, you're gonna have to comply with all of those conditions. You understand?
Sir.
All right, go ahead and sign your notice, and then they'll give you further instructions.
I would know what's shown on the other way. Thank you.
The last person needed
Okay, Your Honor, can we go over the docket?
Let's do it. Hang on just a second. Okay, I'm ready.
All right, I think on Daniel Rand Payne, we just need to announce that he is still in Tarrant County Jail. I verified that on Friday. And that is CR 22-246.
Let's set Mr. Payne in for a status on December 13th. Say for arraignment and status on custody. So Monica Roberts, Steve Green. So yeah, filing the motion for continuance on Friday doesn't give me time to review it or rule on it, or for the state to have an opportunity to oppose it. Have you received the state? Do y'all have an opinion? I haven't even reviewed it. I don't even know what it's about.
I don't think it was even sent to us, Judge, or if it was sent to Ms. Curry, and I haven't seen it.
No, I just checked with Ms. Cassell, and they do not show one in e-file.
Well, I thought you said you filed a motion for continuance on Friday.
I had an email from him saying that he was going to file a motion for continuance. I just checked with, they do not see it in e-file. I haven't been in e-file this morning, but.
But you checked with her this morning,
Yes, sir, she's here.
and Monica Roberts is not there?
No, sir.
Okay, we're gonna have to call her name loudly, distinctly 3 times and take a nice, I can take it under advisement until Thursday, and we'll see what the issue is.
Okay, so let me see.
Isaiah Smith,
Okay, Isaiah Smith was Mr. Massar's, Tom Massar's, and that's the one that appeared at the courthouse this
oh,
morning.
you told me that already, okay.
Ms. Parker reset him.
That, yeah, you told me about that one.
That was dismissed. Okay,
You're not there.
okay, Steve Green has sent something this morning.
It was a motion to continue.
So anyway, let me see, maybe I can log in. Do I have that yet, or is it still in the clerks?
Ms. Barker, can you see if we have a motion for continuance in e-file on CR 22-224?
No response outside from Ms. Roberts showing.
Thank you, Deputy Everett.
Anybody else?
I took one of Jeff's.
So anti-insolvency. It's like, I think about 3 separate things. You're gonna put as an anti, we're within there. Like that tops.
We get to shut all this stuff down.
Don't have. What about?
Not realize it's stones and the other side.
Say anything about me. Okay, we're waiting.
I just heard your voice and I was like, where is this all set up? I didn't even think about it, and I heard you, like, oh, it's there.
Well, I didn't say anything hurtful to me.
What would I say?
And boy,
You sweet, wonderful. I am heartless in a number of ways, but I'm not like that.
No, I'm not. After we go on your thought, yes, you know, again. Let me ask you if you can do it now. Yeah, I can do it now. I just didn't want to do it. But. And we're there. Go back to where wait, I'm confused. Do I need to call Jim to get on it? Well, I just take my own but how that is still available. It's still on. I'll fix it. Your Honor.
Yes. They're in the review queue.
Yes, ma'am.
Okay, they are in our review queue. If I remember my email, he had trial in another county, maybe Cherokee.
I don't see him in my review queue. Do you
I
have?
I think they're still in mine and Waynett's. We haven't sent them to you yet.
Judge, I have them. I can send them to you if you want me to.
Just shoot them to my e-file.
Okay. Thank you.
Your Honor, Mr. Sanders would like to Zoom with you and Ms. Heisel. If you have a moment, we're seeing if he's available to discuss the trial and so we need, will you want Estella to make a record or?
I guess it depends on what Jeff needs.
Stand by, stand by.
And I called Mr. Sanders. Mr. Sanders didn't answer, so I texted him to see.
Okay.
If he's available.
So we're gonna see if he's available and it'll be just a minute.
All right, so on Miss Roberts, I don't know if anybody from Ace Springer is watching, but Miss Roberts needs to report to the court before the end of the day today. And Miss Taberham will be at the courthouse. She'll be at the courthouse this afternoon. She'll be at her office in the courthouse, and she needs to report before the end of the day, or the court's going to fine her bond. The court's going to do a judgment nisi and alias capias.
There's just 7.
So if you can take a break for about 5 minutes and we'll see if we can get a hold of Mr. Sanders.
Okay, we'll do.
And he was, if she had been there.
Used to always get confused completely with that team, and I used to report them all the time. I guess this is Patty of the 294.
That's what's mad, judge, he may or may not be here. I think we can get Zoom on YouTube. Yeah.
Thanks, everybody.
Jeff hasn't responded. He is around.
No, it's more, I mean, see if he's available now. Can you get on? Okay, 9-5, you know the number? He is. Okay, 951.